Be ready for the dictation. The dictation speed is 120 words per minute. 5 seconds to go. The proviso to Order 6 Rule 17 CPC virtually prevents an application for amendment of pleadings from being allowed after the 11/2019 for SCC 332 page 12 of 15 trial has commenced unless the court comes to the conclusion that in spite of due diligence the party could not have raised the matter before the commencement of the trial. The proviso to an extent curtails absolute discretion to allow amendment at any stage. Therefore, the burden is on the person who seeks an amendment after commencement of the trial to show that in spite of due diligence such an amendment could not have been sought earlier. There cannot be any dispute that an amendment cannot be claimed as a matter of right, and under all circumstances, though normally amendments are allowed in the pleadings to avoid multiplicity of litigation, the court needs to take into consideration whether the application for amendment is bona fide or mala fide and whether the amendment causes such prejudice to the other side which cannot be compensated adequately in terms of money emphasis supplied. Initially, the suit was filed for partition and separate possession by way of amendment relief of declaration of the compromise decree being null and void was also sought. The same would certainly change the nature of the suit, which may be impermissible. This court in same case enumerated the factors to be taken into consideration by the court while dealing with an application for amendment. One of the important factors is as to whether the amendment would cause prejudice to the other side or it fundamentally changes the nature and character of the case, or a fresh suit on the amended claim would be barred on the date of filing the application. If the amendment is allowed in the case in hand, certainly prejudice will be caused to the appellant. This is one of the important factors to be seen at the time of consideration of any application for amendment of pleadings. Any right accrued to the opposite party cannot be taken away on account of delay in filing the application. In the case in hand, the compromise decree was passed on 14/10/2004, in which the plaintiffs were party. The application for amendment of the plaint was filed on 8/2/2010, that is 5 years and 3 page 14 of 15 months after passing of the compromise decree, which is sought to be challenged by way of amendment. The limitation for challenging any decree is 3 years. Reference can be made to Article 59 in Part 4 of the schedule attached to the Limitation Act 1963. A fresh suit to challenge the same may not be maintainable, meaning thereby the relief sought by way of amendment was time barred. As with the passage of time, right had accrued in favor of the appellant with reference to challenge to the compromise decree, the same cannot be taken away. In case the amendment in the plaint is allowed, this will certainly cause prejudice to the appellant. What cannot be done directly cannot be allowed to be done indirectly.